All right, I've got 1:30. Welcome to the Ways and Means General Fund Committee meeting this afternoon. If you would, just make sure your phone is silenced. We've had a few reactions over the time here, so I appreciate that very much. And Ms. Harper, if you'll call the roll.
Representative Reynolds?
Here.
Representative Blackshear?
Here.
Representative Hall? Here. Representative Bracy? Representative Easterbrook?
Here.
Representative Gibbons? Here. Representative Lamb?
Here.
Representative Lee?
Here.
Representative McCampbell? Representative Mooney? Representative Sorrell? Representative Sales?
Here.
Representative Underwood? Representative Warren? Here. Representative Witt?
Here.
13, you have quorum.
Thank you. Call the first bill on the calendar, please.
House Bill 1 by Representative Pettis, Alabama State Law Enforcement Agency, Department of Public Health, salary adjustments provided to certain law enforcement officers.
Thank you, Mr. Chair.
Representative.
Thank you, Mr. Chairman. Thank you, members.
Well, if
We're going to make a motion to carry the bill over.
okay. We've had some late discussions this afternoon and related to personnel and Aaliyah, and we've just got to work through some issues. And a representative came by my office and we talked about it. I'm just going to give it a little more time to work on this bill. Anytime you do a pay classification, total pay classification with legislation, you got to be very, very careful because then if something needs to be changed, we've got to come back to this body and change it. So personnel is still working with Aaliyah, and they should be able to follow back up with the bill sponsor the week after next. Have a motion second? Motion second. All in favor say aye. Aye. Oppose? Your bill will carry over to the week after next.
Okay.
Thank you. Call the next bill, Ms. Harper.
House Bill 73 by Representative Pettis, real property tax assessment.
Representative Pettis.
Thank you, Mr. Chairman. Thank you, members. Maybe we'll do better on this one. This is the bill we had the public hearing on last week. This bill, under existing law, there is no limit on increased assessed value of real property. This bill will provide for a cap on real property tax assessments under current conditions. And I think there's an amendment.
Okay, we have an amendment. Ms. Harper, do you have the amendment?
I did, it's in your packet.
Mr. Chairman, I'd like to offer the amendment.
Go ahead.
Replace lines 31 on page 2 with the following, then a 5% increase in the assessed value of the.
Thank you. Any comments related to
That's
the
changing
change?
the 3 to 5, and it's a good amendment.
Yes, sir. And Representative Mooney? It has, and I tell you what, let's agree on this, and then we'll have that conversation. So I have a motion on the table for the amendment. Second. All in favor, say aye. Aye. Oppose? Okay, the amendment is accepted. Back on the bill.
We've been working, we're still working, and working with both, or basically the League of Municipalities and the County Commission Association. We're still working, but we've agreed to go with it like it is, and before I bring it on the floor, we will have a agreement agreed upon. Yes.
If it please the committee, could I ask Mr. Brassfield to come to the mic, please? And I know y'all been very involved in the discussion. I appreciate everybody coming together and meeting with the bill sponsor and also the Lieutenant Governor's office. And if you'll just kind of briefly comment about this, where we are today.
Yes, sir, Mr. Chairman. Thank you very much. Since we were together in this room a week ago today, we had meetings with the organizations representing education as well as the League of Municipalities to discuss some options. We then met on Monday with the bill sponsor and the Lieutenant Governor. We had a very productive meeting. This amendment is an outgrowth of that. We have another idea that I think the committee is aware of that might produce something that could be considered on the floor that would more closely align the cap with the economic activities in particular counties rather than having the same cap. That's not anything that's been agreed upon. That is just something we continue to talk about. This compromise and agreement to move the bill forward today. We absolutely support, Mr. Chairman. We appreciate very much the leadership of the members of the committee in getting us to this point. And the sponsor and I spoke yesterday. I left him alone this morning. It's his first morning without being bothered by me in a while. But tomorrow we'll talk again, and certainly by the time y'all get back, I think that we'll be in a place where we'll be able to move forward.
Thank you, Mr. Brassfield. Any questions? And I think the backside of that, and you correct me if I'm wrong, it just hadn't been stated yet, that if we do vote this out today, then it will not proceed to the floor. That we'll be in a holding pattern until we continue to work together. And I appreciate everybody coming together. I mean, I think that's how we get the best legislation.
Yes, sir. Thank you very much.
Representative Blackshear.
I'll make a motion.
Oh, okay.
Give HB
I
73
I have a motion.
as substitute.
Second. All in favor say aye. Opposed? The bill receives a favorable report.
Thank you.
Thanks, sir. Yeah, stand by just a minute, Representative Keel, and we'll go ahead and call it.
House Bill 275, Representative Almond, Indigent Defense provides for membership and renewed process of boards provided for comp of attorneys.
Thank you, Representative Keel, but she's got to move to another committee. Representative Almond.
Thank you very much. I appreciate it. And I have this notebook that I try to be very organized with all my bills together and all my notes. And it is somewhere in the State House, but I don't know where it is at the moment. So I just stole Carrie Underwood's bill. So I hope I can answer all your questions without my notes. I think I can. So this is HB 275. It's the exact same bill as SB 83, the next one on the list. And what this is amendments to an existing law, and this has to do with our indigent defense program that we have here in the state, and we've had for a long time. The thrust of this bill, there are several sort of minor changes, but the thrust of it is to increase in some categories the hourly rate that attorneys can be paid to represent indigent defendants. And it sets that out in the bill. Primarily, the goal was, first of all, this hasn't been amended since 2011. So currently, lawyers are paid $70 an hour. That includes their overhead, so they can't charge extra for overhead. They can charge for actual expenses, but they can't charge for overhead. So judges are having a hard time in some jurisdictions getting lawyers to even take these cases. So the goal is to raise the hourly rate in some cases, particularly in the offenses that are more egregious, such as capital offenses and Class A felonies. And you can see primarily on page 8, it's where they just list out the actual changes that are made to the hourly rates, and in some cases they're actually, I think, reduced. That's paragraph 6, and there are caps set on all that can be charged by the attorneys. There's a board that oversees this in each county and reviews these fee requests as well. So that is the bill, and before you, and I'll stop and see if there are any questions.
Well, and there's been a lot of work done on this, I guess, really for over a year. And I think it also involves the Class 3, the felonies.
Yes.
And that's the most volume of cases, right?
Yes.
Okay.
Yes, that's right.
Any
There has been a
questions?
lot of work, a lot of give and take on all sides.
Any questions? Ms. Warren?
Thank you. I have not had a chance to read this bill, but I think the thing that really concerns me as we talk about these attorneys for these indigent clients, what do we require out of their performances? Because I'm dealing with a guy right now who his life is totally destroyed because the attorney really didn't want to go in court and just had him to plead guilty. So what are we requiring out of these lawyers for standards? You know, we hire them, we can pay them 70, 80, or 90, but if they're not doing their jobs, what's the checkpoint?
Well, I don't know how to answer that other than to say, first of all, we have to finish law school, we have to pass the bar exam, we have a certain amount of annual continuing legal education credits that we have to get to maintain our bar licenses. And beyond that, I suppose a judge, if judge is in the case and sees poor performance, out of an attorney to the point that it's reportable to the bar, that there certainly is a process to do that in our profession.
It just disturbs me when I hear cases like that.
Sure.
You know, because they can't afford a personal lawyer. So their lives are really at stake of this person that we paying $70
Yeah,
an hour to.
yeah.
If there's no other questions, we'll adopt an amendment. Representative Blackshear.
Replace lines 317 through 324 on page 12 with the following: Attorney General. Replace line 400 on page 15 with the following: strike 3 and renumber it 8 within a reasonable time after the disposition. It's hard for me to say today. Disposition. Replace lines 404 through 410 on page 15 with the following: for payment by the state comptroller.
Any questions on the amendment?
We do consider this a friendly amendment.
Thank you. I'll entertain a motion. Motion to adopt. Have a motion and a second. All in favor say aye. Aye. Opposed? The amendment is adopted, and we're now back on the bill.
I would move for a favorable report.
Entertain a motion. Move and a second. All in favor say aye. Aye. Opposed? Your bill receives a favorable report.
Thank you very much.
Appreciate your work.
Can I ask for a favorable report on SB 83 also?
We can, but I feel like, Senator, I think we need to adopt the sub up front, because that's what the committee members have.
All right, well, I'm
So-
going to let him handle his own bill then. How about
Okay.
that? Thank you very much. No.
Senator Smitherman,
Go ahead.
welcome, Senator.
Good morning.
morning.
Afternoon. How y'all doing?
Good, good.
Good, good. We just, you've heard, I'm just gonna say ditto, ditto, ditto.
Okay.
That's all I need to say, because it's the same identical thing, so,
So the sub mimics her bill exactly, right?
it's the same
So
identical
if it
thing.
pleases the committee, I would, first of all, any questions? If not, we'll go ahead and entertain a motion. Have a motion
Excuse me, I'm sorry, Mr. Chairman. It mimics it as amended.
as the sub will read. Yes, sir.
You have to amend this one.
Same thing.
So we got an amendment. So I have a motion and a second. All in favor, say aye. Aye. Opposed? And now we'll amend that. Okay, in a second? All in favor, say aye. Opposed? Senator, your bill receives a favorable report.
Thank you very much.
Thank you, sir.
Thank you, members of the committee.
Oops, I'm sorry. I'm 2 tiers in, need to go one more. So, back on the final passage of the sub, and the bill, it's now the bill. We have a motion and a second. All in favor, say aye. Opposed? Now your bill receives a favorable report.
Thank you all again.
Yeah.
Appreciate you.
Thanks, Senator. Call the next bill, Ms. Harper.
House Bill 212, Representative Keel, retirement benefits, revised circumstances when an individual's pension, annuity, or retirement allowance benefits are subject to certain recovery actions.
Thank you, Mr. Chairman.
Welcome.
Appreciate the opportunity to present this bill. What you have in front of you is the current method of if there is a judgment against someone of getting restitution back from RSA, ERS, TRS. And there is a line in the bill, 2 lines actually, lines 111 and 112, that I'm asking to remove, and it is a bottleneck to the system. And my DA brought it to my attention. The DAs approved of this. I met with RSA last year. We passed this bill last year through the House, and it ran out of time in the Senate. And so this version has already passed Senate committee. And so I'm on the same bill again this year. But if you look at page 4, 111 and 112, it removes the district attorney's restitution recovery division from the process of getting restitution.
Representative Hall.
So my question was, how is that a bottleneck?
The way I understand it is that currently, I know an example where a person owes $700,000, and as long as they pay $50 every 90 days, it bumps them again. And I'm told by my district attorney that this is the bottleneck that allows that to happen.
I didn't understand. What do you mean bumps them again?
It bumps them out 90 more days, and so they don't have to attempt to gain restitution again. So they'll come in, they'll pay $50, and then that satisfies the process for 90 days. And then after 90 days, they can come back in and pay $50 more, and then they never pay off what they owe. I mean, they're not even making any kind of interest payment by that.
So are you saying that you want them to pay $50 every month as opposed to $50 every 3 months?
I want them to do what the judge says they should do. So if the judge has ordered them to pay restitution based on their ability to pay, that's what I want them to do.
Well, I guess I'm missing something. It says it's been assigned to the district attorney's restitution recovery division. The inconsistency, I don't understand, you saying they only pay $50 every 90 days. Is that a part of the agreement? I'm trying to figure out if there's an agreement, how does that?
It's evidently part of this district attorney's restitution recovery division is what allows that to take place.
Doesn't make sense to me.
Any other discussion by the members? I'll entertain a motion. I have a motion and a second. All in favor say aye. Oppose?
No, I don't know what that does.
Your
Thank you, Mr.
bill
Chairman.
receives a favorable report. Thanks, sir. Next bill, Ms. Harper.
Okay, I got you. House Bill 220 by Representative Ellis, taxation creates Tourism Tax Protection Act.
Representative Ellis.
Thank you, Mr. Chairman, for the recognition. Thank you, members. HB 220, we're calling the Alabama Tourism Tax Protection Act. I kind of described it as a simplified seller's use tax for Airbnbs and online rental platforms. It requires a booking platform or accommodations intermediary to collect the state and local lodging taxes at the point of booking. Let me point out, this does not levy any kind of new tax at all. That's set up by statute today. All we're doing is changing how that's collected. Right now, there's confusion. Some online platforms collect it. Some owners of the units collect it. But there's a lot falling through the cracks there. So this would make, at the time of booking your Airbnbs and such, collect those taxes. It also ensures that if you are an owner collecting the taxes, even if you use Airbnbs some of the time, not all the time, you can continue to collect it yourself per the contract with the Airbnb. So you don't have to, the Airbnb does not have to collect it. There is a substitute that the main change in that substitute is we were trying to exclude property managers that do short-term property management, anything under 6 months. Of course, it's subject to lodging tax, but we're trying to exclude out property managers that maybe manage an apartment complex that occasionally, instead of a year lease, it may go to month lease. With that, it's the Department of Revenue bill. They're here in the room. If we've got any easy questions, I'll handle. If you got hard ones, I'm gonna step back and let them.
Let's go ahead and adopt the sub, if that pleases the committee. All right, we have a motion and a second. All in favor say aye. Oppose? Okay, we're back on the bill.
And what I've described to you is the substitute.
Okay.
Are there any questions?
Representative Eastbrook?
If they don't pay the sales and use tax, in that case, sales tax, what are the consequences?
The lodging tax, if they don't pay the lodging tax, I'm not sure if I know the answer. Here come the smart people.
Mr. Chairman, I think on line 128, it says the Department of Revenue shall adopt rules for the implementation.
Right, hey, committee, thank you, Chairman. Cameron Clark from the Department of Revenue. And right now, the tax is already due. So you already have that liability to collect the tax. If for example, a booking platform does not collect it, then that liability falls on the owner right now. And a lot of times, those owners don't realize that they should be having that lodging tax collected and due. So this kind of takes that away and just says, hey, if you're booking on a platform and you're not remitting the tax already, then the booking platform collects it on your behalf and remits it to the state and local governments.
My question is, what happens if they do not remit, the landowner or the property owner?
Well, right now, it would be difficult for us to determine exactly who that might be. So for example, if I was to put my property on there to book, the state doesn't necessarily know that I'm not remitting the tax, and that's where that loophole comes in. And so what we're doing is kind of closing that to say, well, you know, the tax is collected at that point of sale, almost like every other sales transaction.
But assume that you do know. What can you do if somebody refuses to pay the tax?
They would go through the normal process of an assessment, that type of audit aspect, and those normal provisions and protections that are in the tax bill of rights as well. So it'd be the normal process.
Any other questions? Thank you, Ms. Clark. Thank you. We're back on the bill. I'll entertain a motion. Have a motion? Second? Second? All in favor, say aye.
Aye.
Opposed? The bill receives a favorable report. And I think you have HB 256 next. Go ahead,
I
sir.
do. Thank you, Mr. Chairman. Members, HB 256 is a Sheriff's Association bill, and it will change their reimbursement rate for when they go and extradite prisoners back to the state. Currently, they're getting paid $8 per day and 10 cents per mile, which is obviously way below. No telling when that was set, but it'd bump that up to $100 per day, and the mileage rate for state employees, which is currently 67 cents per mile.
I have a motion and a second.
Second.
Second. All in favor, say aye. Opposed? Bill receives a favorable report.
Thank you, Mr. Chairman. Thank you, members.
I'll call the last bill, Ms. Harper.
Senate Bill 81 by
that's the wrong
Senator
one.
Singleton, boards of registrars further providing for the membership of each board,
Okay, the wrong
increasing the
bill.
salary of each registrar, and providing for the employment status of each registrar.
And this will be a public hearing. There will be no vote today, members. Representative Leader. Singleton.
Hey, leader, how you doing?
Yes, sir.
It's ironic I just walked in the door right on time. Good evening, committee.
Hello.
And thank you, Mr. Chairman. Thank you for hearing this. I really appreciate this going on public hearing. I expected nothing less. It went on public hearing in the Senate also. I understand there may be some miscommunications, or people may have a feeling that some positions may be lost or what have you, and this bill does none of that. And what we'll find out is that this bill, under current law, members of the Board of Registrars must meet certain qualifications. They meet those qualifications, and under the law, the governor, the auditor, and the Commissioner of Agriculture and Industries appoint those registrars. The bill is a code amendment that will require that the governor, auditor, and the Commission of Agriculture and Industry to work together to ensure that the diversity and the racial makeup of this state is there. Because I personally feel that Board of Registrars should not be whether or not from parties or other, but where they can. If they can't, then they will make the appointments as they need, okay? And this bill requires that the register receive a salary increase from $80 to $100, trying to give them a pay raise. The bill also ensures that members of the board consider whether that they are county or state employees. The bill requires that the Board of Registrars do the following things. 1, be open at the hours of the courthouse of the county, or alternatively, establish regular hours and meet those hours available to the public. And 2, to have a registrar present during those hours. We're not saying they got to be there every hour. They get to set their own hours. And while they set their own hours, all we're saying is that at least one person be present when the courthouse is open to give people access to the Board of Registrars. So the bill does 3 basic things. Number 1, it sets up pay raise for them. Number 2, it allows the governor, the auditor, and appointing authority to look at the racial and demographics in those areas, and if they can, and where they may, they can ensure that that would happen, okay? They don't have to. This is not a mandate that they have to do that. And we're just asking that they consider it. And the third part of it is that they set hours and be available when the courthouse is open. We're not saying they have to be there every day that the courthouse is open, but they set their hours and make it public as long as the public know when they're going to be there. Even if and I know in the Senate hearing, they said, well, sometimes we have to go off to training. Well, if you're going out to training, make it know that people you going to train, and people know that they can't register during those days that you're out to train. They'll just come back on the days that you're going to be there. All we do is ask that the public have notice of when your hours are going to be, and people would know when they can come and register to vote. That's basically what this bill does. It has no intent of taking anyone from their position currently, replacing anyone. It's just about that appointing authority being able to make those appointments appointments and just consider the racial and demographics of the state of Alabama. That's it.
Thank you. Any questions for the leader before we move into the public hearing? Okay, I'll allow me
Thank
to
you.
call the first
I appreciate
person. Sonny Brasfield, proponent.
Mr. Chairman,
Welcome,
members
sir.
of the committee, thank you very much for the chance to talk to you about this legislation. That is one of our priority bills for the coming session. In fact, this legislation is we've worked on for the last 3 years. The bill began with a number of proposed changes to the Board of Registrars and has been whittled down to what are the focus of 3 or 4 things that Senator Singleton mentioned to you. First is the diversity language that is found on page 2. I think if you look at it, you'll find that language to be as he described. It is not a mandate. It is not a directive. There is no punishment if this language is not complied with. It simply goes on record as saying that this legislature believes that the appointing authority should consider the demographics of this state in making those appointments. We think that's fair. I will say to you, our legislative committee is composed of one person from each of the 67 counties. For 3 years in a row, they have approved this language unanimously. Our membership adopted this as a priority unanimously, and we believe this is something that we should do because the registration process is one of those things that we should all strive to reflect our state in terms of the people that are on the ground helping that work. There is a pay raise in here for the registrars that we will say is long overdue, and the association supports that. Then there is the provision that deals with the hours that are to be open. Those hours are to be posted, but it does not mean that they have to be open all the time the courthouse is open. They simply say when they're going to be open so that persons that are traveling distance to come to the courthouse know that they're able to be there to vote. And the only other thing that is in the bill is a statement that these persons are neither county nor state employees. That they're appointed by 3 state officials. They do not receive state benefits. They're not county employees either. The commission doesn't supervise them. The commission has no direct control of their hours or activities, and this just makes it clear that the county commission is not the employing authority, Mr. Chairman.
Thank you. Any questions, Mr. Brasfield? Thank you, sir. I'm sorry. Chairman Lee.
Who does the supervision for this?
Mr. Chairman?
Yes, sir.
Representative Lee, the Secretary of State does have the authority to receive essentially review and complaints and can recommend that there be changes made in the personnel, but the county commission doesn't have any involvement in that.
So there's really no one that does daily supervision of them?
Correct. Yes, sir.
Isn't that a problem with anybody?
As I said, we had a bill that did a number of other things 3 years ago, and we ferreted it down to this. But some supervision was one of the other things that was in the bill. Yes, sir.
Any other questions? Next speaker, opponents, Ms. Sydney Dean. And I hope I get this right. Alabama Associations of Boards of Realtors? Registers? Is that right?
Thank you very much. Good afternoon, Chairman Reynolds, Ranking Minority Member Hall, and honorable representatives of the West Fund Committee. My name is Sydney Dean, and I'm proud to speak with you today as the newly elected president on behalf of the patriotic and hardworking members of the Alabama Association of Boards of Registrars. As an attorney in the Army, I was privileged to speak in front of many panels, but never a House committee. I'm honored to be given the opportunity to make this statement before you this afternoon. I know it's been a long day. I intend to be respectful of your time and to the point, but several issues have been raised here. This bill is not what it seems to be at first look, and I want to go into that very briefly. Our association has been in existence for decades and is the largest and only official association representing registrars in this state. As a body, the registrars of the association are against this bill, and we appreciate the opportunity to explain briefly why. We especially appreciate this hearing today as none of the sponsors of this bill have contacted us about this bill, a bill that only affects registrars. Our association was planning to put in for a $70 per day raise this term. So when we heard that someone else had put in a raise for us, we were surprised and looked forward to reading the bill. Then we read the bill, and we understood why registrars had not been consulted. It is an awful bill for registrars. It's a slap in our face. There's only a $20 raise, which keeps registrar pay way below the poverty level. When just last year, the legislature approved poll workers receiving $150 per day, and no disrespect to poll workers, but the duties of registrars are far, far greater. We will lose health insurance under this bill. About 1/3 of the current registrars will lose their positions because they are the wrong skin color. Some races cannot be considered at all for registrar appointment, and one registrar is required to be in the office during operating hours at all times, no matter the circumstances, or be in violation of the law. This is not my interpretation. It's what the bill says. I understand that you'll have copies. I'm going to go to this language briefly. Under Section A, lines 54 through 58, it states that membership of the Board of Registrars shall be reflective of the racial demographics of the state, not may, not if they want to be, but shall. This is mandatory language. It's not permissive. Alabama Demographics, published by the Culverhouse School of Business at the University of Alabama in 2020, reports the racial demographic of the state is 66.8% white, 26.5% Black African American, and 6.2% other races. This would mean by law that one registrar would be Black African American in each county and 2 white. So again, the demographics that are reflective of the state, not the county. Hispanics or Native Americans cannot be appointed as registrars in Blount, Chilton, Coleman, DeKalb, Franklin, Jackson, Marshall, and Winston counties, even though those counties have Hispanic or Native American demographic as their second highest population. To be plain, under this bill, Hispanics, Native Americans, and Asians can never qualify to serve as registrars under any circumstances. This bill does not say racial minorities, as it does in some bills that have passed this body. It says racial demographics of the state, not the county. These are important distinctions. Also, under the clear language of this bill, it would bar counties with majority Black African American population from having more than one Black African American registrar. These counties include Bullock, Dallas, Greene, Hale, Macomb, Marengo, Montgomery, and Perry. Majority Black counties would be forced to have at least 2 whites and only 1 Black registrar because of the language, again, within this bill that says the Board of Registrars in each county shall be reflective of the racial demographics of the state. If the bill becomes law, over 1/3 of current registrars will lose their positions. Some of these registrars have served faithfully for years, helping to set records for state voter registration, and do not deserve to lose their positions simply because of the color of their skin. Consider also that the racial quota required under this bill invites lawsuits. Certainly, the proponents of the bill will bring suit if the appointing authorities do not appoint 1 Black and 2 white registrars in each county. Last week, the Pacific Legal Foundation, or PLF, filed a lawsuit on behalf of the American Alliance of Equal Rights to stop what it alleges is Alabama's unlawful racial quota appointment to the Alabama Real Estate Appraisers Board. The Appraisers Board has 9 members, but state law demands at least 2 must be racial minorities. PLF stated it is committed to defeating race quotas in Alabama free of charge. And for those who would like to pull a case, I've got it with me. I can give it to you later. Going to Section 1, lines 137 through 140, it states that no registrar is a county or state employee. You may not be aware that some registrars have successfully negotiated health insurance benefits within their county and are now considered county employees for the purposes of health insurance benefits. And so the practical effect of this bill's language is that their current status would be negated, causing them to lose medical coverage for their families. This would be a cost savings to some county commissions, but would hurt families of some of the constituents that you represent. The bill's statements that registrars are not state or county employees is also wrong on its face and simply not helpful. We are a hybrid of both state and county. Under current law, the county is responsible for some areas of registrar employment, such as providing office space, electricity, water, internet connection, et cetera, and the state other areas of employment, such as training. What would make sense and be more beneficial to everyone in the long term would be for the proponents of this bill to communicate with the registrars and the Secretary of State's office to establish a classification for registrars that is workable instead of consigning registrar legal status and responsibility to some strange no man's land with no health insurance and possibly no support for the registrar's physical offices. Section J, lines 141 through 146 states that on working days, the BOR shall do both. It says both, BOTH, of the following. Be open at the same hours as the courthouse or establish regular hours and have a registrar present during those hours. Line 146 statement that one registrar must be always present is impossible and impractical. It may not be possible or advisable for one registrar to be always present due to illness, emergency, pandemic like COVID, required training by the Secretary of State or other reasons. Again, the language is both. The language actually says both. Equally as important, the number of days each year a registrar may work in each county is set by law. Some are allowed to work 260 days per year, or what could be considered full-time, and others as little as 120 days each year in counties such as Wilcox, and everything in between. So obviously, the courthouse may have more open days per year than working days allotted for the requisite counties. Because the law says that registrars have limited number of working days per year under the language of this bill, not what we think it's supposed to mean, but what it actually says, registrars will be breaking the law if at least one were not present at all times during regular office hours, which means that a registrar would have to work without pay if the working days allowed by law had already been met, or come to work even if ill, et cetera. In closing, registrars uphold the integrity of the voting process and make certain that every vote counts. They are essential for democracy to function properly, and they work tirelessly to ensure that everyone can exercise their constitutional right to vote. Registrars' responsibilities in recent years have increased dramatically, along with Alabama's explosive population growth. They are solely responsible for the management of over 3 million voter files, monitor felon voting qualifications. Over 43,000 were incarcerated in 2020 alone, and evaluate requirements, which include citizenship, for issuance of thousands of voter identification cards used at polls to vote. Due in large part to their diligent work, Alabama has an election system that is imitated by other states across the nation. The Secretary of State's reports that record numbers of people are registered to vote in Alabama, the highest in Alabama history. So, with registrars doing such a good job, what are the proponents of the legislation really trying to do here, and why? I believe this bill has unintended consequences that perhaps the proponents did not see. Did they intend for registrar families to lose their medical insurance? Did they intend to make it so registrars would be violating the law if at least one was not able to work during regular office hours? Did they intend to exclude every race, Native American, Asian, Hispanic, all races, except for white and black, from being registrars? Did they intend for predominantly black counties to have only one black registrar? Did they intend for 1/3 of registrars to lose their positions? I don't know the answer to those questions. But what I do know is that now all of you do know. This bill is fatally flawed. It's a discriminatory bill, and it's hurtful, and it should be stopped.
Let's wrap it up so I can allow the other speakers to go. Next speaker,
I
Mr. David
appreciate your
Russell.
time. I know we can accomplish great things if we just talk to each other, and it's my hope that the proponents of this bill will at some point talk with the registrars and get with the Secretary of State's office, and let's discuss what the issues are together, and let's work for a solution to problems
Thank you,
or
Ms.
issues
Dean.
that we're seeing here.
Thank you.
Thank you.
Next speaker, David Russell.
Let me say good afternoon, and thank you for this opportunity. Kind of scared behind all of that. but actually, though, seriously, I thought that was a pretty decent bill because I'm originally from Sumter County, and I have a nephew and several other folks that live in Sumter County in Cuba, Alabama. They works in Tuscaloosa daily, so it'd be difficult for them to have to leave home in time or register before they leave, because when you leave, the precinct is closed, and when they get back, it's closed. So I really think it would be a good idea if the time of the registrar office is going to be open, so they would know. Some of them might be off on a Monday or Tuesday, they can get ready to vote. But where it's set up over in Sumter County, he has several people over there that works over in Tuscaloosa, which is about 70 or 80 miles where they work. But what I really would like to see in terms of this bill is that they added during the voter registration day when people works at the poll. I really would like to see for them to have a set rate to pay people. Like, again, over in Sumter County, I think they pay them, if you're chief inspector, I think they get $120 a day. If you're a regular worker, you get $80. In Birmingham, I think you get $200 a day if you was a poll inspector. If you works at the polls, you get $150. But now, I had the opportunity to work both of those senator races over in Atlanta. And when those people work the polls in Atlanta, the chief inspector get $400 a day, and the person that works at the poll get $350. So I wish that we can be consistent in terms of what we pay everybody. Birmingham get a raise, Sumter County get a raise. I wish we had a flat rate that we can pay everybody the hour that they work. Thank you very much.
Thank you, Mr. Russell. So back to the bill sponsor. Does the members have any question?
Where's the bill sponsor?
You representing the bill now? Okay. Any questions?
I have.
Good?
I have a question.
Yeah, I have some questions.
Representative Easterbrook?
Is this the way that she explained the bill? Is that the way that you see the bill?
Representative, I obviously read something different than she read. I didn't see that in the bill. Now, if necessary, we can read the lines and everybody can make their own interpretation. I did not see that. It said membership of each board of registrars is reflective of the racial demographics of the state. Didn't say black, didn't say white, it said the racial demographics. It could be Hispanics, it could be American Indian, whatever the racial demographics is, that's what the bill means. It doesn't say any particular race. So I don't know how you read that in that just means blacks and whites. I don't understand that part. The other part was as county and state employees. County and state employees are subject to the employment system within counties and states. They wouldn't have to ask to set hours. The county commission would set the hours of the county employees. They would also set the benefit schedules. They would also set what days you work. I mean, so that's the situation is people have looked at registrars as being either state or county employees, and the bill has no problem with the county wants to offer you medical benefits. The bill doesn't stop that. It just simply says it needs to be cleared up that they are not state employees, they're not county employees. They work within the courthouse, and the county commission is to provide certain services for them, but do not direct them at all. The other part of it is the raise was put in to give a raise. Now, I think the earlier speaker said they were looking for a $70 a day raise. The $20 a day raise is what the County Commission Association agreed on, and that's why that's in here. And the other are really are technical amendments just to clear up and bring it into line with what the present law is. But this is not uncommon. We do this in the legislature all the time. When we appoint boards, we look at the racial demographic. Sometimes all the demographics are the same. So that's what you do. You appoint from that. And I mean, that's simply what it says. There is no adversarial approach from the counties or from the state as it relates to registrar, but some things just need to be cleared up. It needs to be a clear definition between, and I think Representative Lee asked, well, who supervises? Well, the county doesn't. They do take direction from the Secretary of State on certain items, but he does not supervise the day-to-day operation of the Board of Registrars. So I really think that what we have here really are adjustments that are necessary to establish what the county's position is, what the board's position is, and how they operate. That's all this bill is really intended to do. It's not intended to do anything other than that.
Thank you. Any other questions? For the benefit of the new members, you know, this bill has been in front of this committee for a couple of years, and we were asked to hold that until all the Board of Registrars were kind of on the same page with it. I met with them, took the time to meet with them this year. Clearly, there was a clear separation, but we wanted. I told the sponsor that we would have this public hearing. There would be no vote today. It certainly sounds like there's more work. I did, for the purposes, and I'm not trying to sway the board either way. I'm just feel like as chairman, I need to some clarification here. I did turn around and speak to the attorneys, but I mean, I don't think anybody would lose their job over this. I mean, no. It says shall work to assure. It doesn't say shall appoint. No. So I don't, if I'm reading that wrong.
It's for future appointments.
Right.
It's for future appointments. When
The
they
work
have
toward
future-
is not must.
No, it's not for anybody to leave that's there now. Right. When their terms are up, then we ask that they just consider the demographics. That's all.
And they still have to meet the minimum qualifications.
Yes.
To be considered by the appointee.
Well, the other thing I might say about that, if you're a county or state employee, they are going to determine what the qualifications are for you to be on.
Right. Okay, if there's no further questions.
Mr. Chair.
Yeah,
So
Ms. Hall?
we've been talking about this for 3 years, and then we have this opposition. So I'm trying to see, what is the trigger for the opposition other than what was stated? I mean, what triggered that?
I'll let someone else answer.
Briefly. Ms. Dean.
What triggered the opposition is the question?
Yes.
Representative Hall? Because it's a bill that's against the registrar's best interest. The raise is too low. We believe we would lose health insurance benefits, and we do believe this language says it shall, not that they can just consider. If it was, they may just consider, why doesn't the bill say they may just consider? It doesn't say that. It says they shall consider the racial demographics of the state. We're looking at what the language actually is in the bill and not what is being said they think that it means or they intend for it to mean.
Okay, thank you.
Representative McCammell.
I have this question. When it says that they shall consider the racial demographics of the state, do you feel they shouldn't? Is that what you're saying? They should not even consider the racial demographics of this state? Is that your position?
No, not at all. They can consider racial makeup, but when this says they shall consider racial demographic, then you look to what the racial demographic is of the state. Words have meaning. What does racial demographic
Hold on
mean?
just a minute. Yield to each other. Ask the question, then answer it.
I'm sorry. Go ahead. What's the question?
The racial demographics of this state is, as you said, 28% African American, 6% Hispanic, and then 1 or 2% other, whatever it may be.
That's not what I said.
But that's the racial demographics. It doesn't say black folks or white folks. It said racial demographics of the state.
Yes.
It shall consider that, not black or white. That's not what it says.
But the racial,
But it
is there a question?
says that it shall consider the racial demographics of this state. The total racial demographics of this state.
Yes, and your question is?
That is, no, it's not a question. That's a statement as to what this says.
Okay. Thank
Yes.
you, Representative McConnell.
And I made my, and yes, and racial demographic has a definition. And if you look at that, you see what the racial demographic is. Otherwise, what's the purpose of the language? If the language, the purpose is that it should just be considered, then the language should be permissive and it should say may consider.
Thank you, Ms. Dean.
Thank you.
You make a final comment, Mr. McCammell?
I need to make a final comment.
Oh, yes, sir, go ahead.
You know, right now we are starting to consider DEI. That's one of the things that we are considering as a body in this state. If we only had to consider EI, equity and inclusion, then it wouldn't be any problem with the diversity and of the demographics of this state. There wouldn't be any problems. But we live in a state where we don't consider EI. So DEI has to be something that we talk about. But I'm one that believes if we lived by the creed that we say we live by, then EI would be what's important to us. And then diversity wouldn't be any issue at all. But it is because we are human, we are flawed, all of us. And because of our flaws, we have to really consider what we are doing to our fellow man, period. Thank you, Mr. Chairman.
Thank you, Mr. McConnell. Any other comments? Representative Mooney.
But if I understood what...
Mooney is recognized.
I just have a question. Excuse me. I just have a question. This has been going on for 3 years, and we have this kind of opposition and this kind of controversy over something. Obviously, in the 3 years, there's not been conversation between the two groups. It would seem, I guess, I haven't heard it before come up in our committee. Something's flawed here, to use the representative's expression that he used. I mean, this doesn't make sense that there's not an ability for the parties to sit down and come together before bringing it to this committee and creating something that is a controversy for this body to consider it in an inappropriate way, I believe.
Mr. He's just making a comment. Representative Easterbrook.
If I understood what she said right, they said consider the state demographics, but apply it to the county. So if you went to Wilcox County, what she was saying, this majority black, you would end up with 1 black registrar and 2 white. So I don't know if I understood it correct or not, but that's what it sounded like to me. They want to take the state demographics and apply it to the county. That's what she said. I'm not saying that's what the bill, I'm not a lawyer. That's what she was saying. That's why she was saying people would lose their job. Yeah.
Okay, this brings to an end the public hearing. I do encourage all parties to continue to work together. This has held this up for quite some time, so I'll entertain a motion.
Motion to adjourn.
So moved, sir. Thanks, everybody, for hanging.